Megan Woods.
Mr Speaker, it's not with pleasure that I take call on another piece of amending legislation to the Exclusive Economic Zone and Continental Shelf legislation, because this is not the first time that this House has had to come and play fix-up on what was a badly drafted piece of legislation to begin with. Mr Speaker, the Labour Party will support this legislation to Select Committee. We will support it so there can be a scrutiny of the legislation. We will support it so that we can hear from the interested parties and that we can hear from the communities. And it does give us a chance to examine this legislation in the context of what we think is actually a much larger and looming issue in regard to this legislation, and that is further changes to this legislation that may be coming down the line within the next year or so, and I'll address that more fully later in my speech, Mr Speaker. But what I want to talk about, and we heard from the Minister that she telling us that it is inevitable that with legislation such as this, that there will need to be amending legislation and that there will need to be some fixes made to a reasonably complex regulatory regime. Well, Mr Speaker, it's not inevitable what this Parliament and the previous Parliament have had to do to pay fix-up to a botched piece of legislation. If we had a look at when it was first passed in 2012. So this is not a piece of legislation that has been on our statute books for very long, and it was full of errors. It required a major redrafting at the Select Committee stage. And this was by very hard work by the Select Committee, and I commend the Select Committee from that. But even after that, more errors were found, and the responsible minister at the time, the Honourable Amy Adams, had to put forward 14 pages of supplement, had to put forward a 14-page SOP to fix it. So this is a badly drafted piece of legislation, a rushed piece of legislation that from the very moment of its beginnings has been tried to be resuscitated and tried to fix. But only a month after the EEZ legislation law was passed, the government had to pass another 37 pages of amendments to it as part of the marine legislation bill. Another 37 pages. This simply isn't good enough, and it is not good enough for the Minister in the House today to call this inevitable. I would not want to be it's holding up as a shining light this level of amendment and fixing of legislation and calling this something that's inevitable or something we should aspire to in our lawmaking. It simply doesn't meet the standard, and it's not good enough. So then, even after the 37 pages that we saw of amendments that we saw in the marine legislation bill, there were several more SOPs from the Minister in charge. In that instance, it was the Honourable Jerry Brownlee. This is now the second piece of fix-up legislation we're seeing in the last 3 years. And my concern from hearing from the Minister today to brush this off as merely inevitable is how many more times we're going to be here. How much more time of the House, how much more Select Committee time is going to be chewed up by fixing this piece of legislation that was flawed from its very beginning. It is another sign of this government's incompetence in handling legislation. Another example of how this government is passing bad law into our statute book, and we are using so much of our time trying to rectify their problems. It was badly drafted, it was weak law, and it was rushed through the House without proper consideration. And Mr Speaker, the amount of fixes that we're having to do is testament to shoddy process and what that brings about. And now we're having to sit through yet another bill fixing it. So for the Minister to call it inevitable and to say it was a shame that Shell Energy didn't get their application in time to allow for appeals actually isn't taking the responsibility that needs to lie with the government for the bad piece of legislation that was passed that allowed this circumstance to arise. What was reasonably inevitable that there weren't adequate transition provisions in order for companies that had existing consents to transition to the new new regulatory regime. And it's another example of how the government did not think through properly what needed to be in the legislation. So as the Minister has outlined, this piece of legislation that we're here talking about today is essentially to allow an existing operator to keep operating while their consent is processed, but not only while their consent is processed, to allow time for any appeals that may or may not be lodged in regard to that application. Now, Mr. Speaker, this is something that could have been foreseen. We have a limited number of existing consent holders that needed to transition into the new regulatory regime, and the legislation, the primary legislation that was passed only 3 years ago, could have accounted for this. Instead, we have a minister who's blaming the consent holder for bad legislation and her contribution in the House today. And what we have is a government that has put a chunk of New Zealand's gas supply at risk if this legislation isn't passed and isn't cleaned up, if this mess isn't cleaned up. So, Mr. Speaker, the government needs to take responsibility for this and not simply blame other people. But, Mr. Speaker, this legislation does give us pause to wonder what it is the government is planning next for this Act. What we've seen is a great deal of chatter, if you like, following the Chatham Rock phosphate consents being declined only a few weeks ago, and claims now that the government is supportive of reforming the law to ensure that projects like that could be consented. Nick Smith has not ruled out changes to suit the seabed mining industry. And, Mr. Speaker, we will be watching very carefully at Select Committee to make sure that this legislation isn't any attempt to fundamentally alter the legislation and to get through the back door changes that we know the government wants to do. We're expecting this will probably come in yet another piece of amending legislation to this primary legislation. So we'll have another exclusive economic zone and continental shelf amendment act to deal with this year, I would imagine, and that will be something this House will have to turn itself to again, because this bill is not the primary act is not doing what the government wanted it to do, and it's to enable economic activity rather than act as the environmental protection that actually the Environment Protection Agency has seen itself able to do in regard to this. And after the Chatham Rock phosphate decision, we have seen a great deal of posturing from a number of people that talk about the changes that need to be done. We're told by the CEO of Chatham Rock Phosphate that he's actually made a number of suggestions around how it is that the legislation needs to be changed. And this might be something that we may need to consider when this bill goes to Select Committee. Any other changes that the government is considering to the primary piece of legislation, because, Mr. Speaker, passing an amending piece of legislation, if we're going to be presented with yet another piece of amending legislation in only a very short space of time, will be something that we will have to consider very carefully on this side of the House, that we will have to ask some very serious questions about when the next piece of amending legislation is due before this House and the Local Government and Environment Select Committee, where I'm assuming this bill will be going. And these will all be, that's what the Minister said, thank you very much, these will be questions that we will be asking when we get the chance to examine this. Because, Mr. Speaker, this is a government that needs to lift its game well, in many respects, but it needs to lift its game in the quality of legislation that they are passing. They are passing shoddy legislation, they are passing hurried legislation that doesn't go through proper process. And surprise, surprise, we're getting mistake after mistake after mistake. And too much of this House's time is spent fixing up this government's mistakes. And too much of our energies are spent doing that rather than doing something proactive. And, Mr. Speaker, to have the Minister blame the company, as she did in the House today, to say they should have got their consent in earlier, just does not take into account the poor legislation. So, Mr. Speaker, we have a government that in 2012 passed legislation that didn't have proper provision, that could put at risk a vital piece of our energy supply in this country, that could put at risk 300 jobs in the Taranaki region, if this isn't fixed up, because the original intent of what we're doing here it wasn't properly spelt out in the primary legislation in 2012. And Mr Speaker, we will support it to Select Committee, but we will be asking some very serious questions of the government at that stage.